For pronouncement of judgment, item 38.
For the reasons assigned, the writ petition stands allowed. The order passed by the learned tribunal stands set aside.
Production list for pronouncement of judgment, item number 1, writ appeal 206/24. Item number 2, writ appeal 301/24. Adjournment request, if any, from item number 1 to 5.
Wait, please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item number 2 of today's daily. Obliged.
From item number 6 to 15.
Wait, please, Your Lordship. I beg to mention item number 14. Yeah. Item will come after 2 weeks, Your Lordship. Modification. Lordship, the engaged counsel.
If it is beyond the problem.
From item number 16 to 26.
May it please your lordship. Well, in item number 20, we have filed an affidavit in opposition taking the ground of suppression of material fact. We may be allowed to bring it on record, my lord. We filed it yesterday. We thought that we'll put it in the record, but somehow we did not.
Whether it is in defect or what?
Mm.
Is it in defect or?
No, it's clear. We had filed it yesterday. Clear. It's lying in the section.
Next week we'll listen to the
My lord, I'm appearing for the caveator only because I cannot.
rules for the others.
Yes, well, let the item be called for. Yes, ma'am.
Let the number come.
Yes, ma'am. I would have been happy if it was part of the record, but we could not put it.
May I please, the Lordship, I'd like to mention item number 24 of the daily list. It may be taken after 10 days, Lordship.
What's the special after 10 days?
Lordship, we are awaiting some instruction from the department to file the affidavit. That is still awaited, Lordship.
July.
Much obliged.
If I may, Your Lordship. I would like to mention item number 23, Your Lordship. The leading counsel has well. Your Lordship may fix it on next week.
August.
Wait, please, Malaj. Malaj, with the consent of the other side, Malaj, I beg to mention item number 21, Malaj.
Adjournment.
Deeply obliged.
Adjournment request from item number 27 to 37.
May it please your lordship. Lordship, with the consent of the other party, I beg to mention item number 32 and 33.
Yeah, please, your lordship. With the consent of the other side, I beg to mention item number 35, my lord. Only senior 35. My lord, matter will be taken after vacation, my lord.
My lord, I'm praying for an adjournment in item number 29.
How many days? कितने adjournment हो?
One last.
August.
Months of late.
Wait for that till next election.
Any other request? Daily list for orders item 1.
Your lordship. Your lordship.
Yes. Yes.
Yes, your lordship, in this item, in this matter, we have received the affidavit from the state only yesterday. I may be given some time to.
Well, that affidavit has also not come on record, but though we filed it day before yesterday. 2 weeks.
Your lordship, a fixed date of 11th or 14th may be given, your lordship, so I may attend. And in the meantime, I will file my affidavit also.
11th or 14th of what? No, not 14th.
11th or 14th, your lordship.
14th is difficult for me. Any other 14th? Which date? Immediately
11th.
after Bihu, my lord. Bihu asking for immediately after Bihu. Yes, ma'am.
23rd.
21st.
Yes, Mr. Counsel.
Okay, your lordship. I'm saying any date after 14th is okay for me.
23rd.
23rd.
Much obliged, your lordship.
Obliged, ma'am. Yes.
Item 3 and 4.
In this case, item number 3, we file affidavit of service. Notice was
service?
yes, Lord, that's the service. In item number 3, it was received by him, but in item number 4, the wife of the one Jahardas received the notice.
Okay. Affidavit of justice service is filed on behalf of the concept of the revenue. Having gone through the affidavit and taking into consideration the acknowledgement report, acknowledgement received, we deem it appropriate to treat the service upon the sole respondent as complete. List after 3 weeks for admission.
In item number 4, the notice was received by the petition of Jahardas,
Received by the
wife of one Jahardas, Lordship. We are filing affidavit. So, Lordship, we will take fresh steps. So,
the item number 3.
item number 3 is correct. Item number 4, Lordship. Here, respondent is Sanjay Kumar Das.
In this, the report is this, that this notice returned with the remark that notice he has left.
No, Lordship, we serve Dusty service only, but it
Where
was
is that affidavit?
we are filing today, Lordship. But in the,
Then if 3
Lots.
weeks order करते ना 4 करते ना 3 weeks.
Lord,
अलग करते हैं. अच्छा साथ में करें.
Item number 5.
Return answer.
Yes, your lordship. That's the last office notice.
As per the Laulima court report, as per the office report, the told respondent has refused to. The respondent number one has refused to accept the notice sent, accept the notice of the writ appeal. Since the respondent number one has refused to accept the notice, the service on the respondent number one be treated as complete. This writ appeal for admission.
Deeply obliged.
Item number 6,
Respondent 12 has not been served with it.
Yes. Yes, Lordship.
Notice upon the respondent
Yes, Lordship.
is unserved.
Yes. Lordship will take fresh steps.
As per the office report, notice issued to the respondent number 12 of the IA number 302726 remain unserved, and it concept for the petitioner, applicant praised for and granted time to
Lordship may allow Dusty also, Lordship.
take fresh steps for service of notice upon the respondent number 12 to register daily in the state within a period of 1 week on taking such steps as notices be issued to the respondent number 12 of IA number 3026, returnable 6 weeks thereafter.
Deeply obliged.
item number 7,
May it please, Lordship. In this case, my lord, we are directed to file an application for impleadment. We have filed it on 4th of March, and registry wanted us to clear some defect, my lord, which have cured, my lord, on 25th of March. So it is not listed. Let it come along in the application.
After a week,
My lord, item number
15.
15 also, a notice was not issued. In the letter notice go on that in this case, and also the same order.
item 8,
Notice in both the petitions returnable 6 weeks.
Deeply obliged. 8 and 9 also similar.
item 10 to 13,
One of the applicants before your lordship are the members of the income tax application.
What are the remarks ultimate?
My lord,
What are the remarks?
may your lordship may find the remarks.
Don't find any objection about it.
My lord,
We don't find any objection.
one of the last part, my lord, the observation is there.
Observation is simply,
My lord, two observations or one observation from your lordship has a great effect on the future prospects, my lord, of the career of the of the tribunal members. You also can see
Para number 20,
22
22.
at page 106.
Yeah.
May I read, my lord? We have also taken note of the fact that the bench of the tribunal in earlier decision dated rendered on so-and-so, which is relying on the decision of Delhi High Court, has held that the explanation inserted in section 4 was applicable respectively. However, the same bench, while deciding business application, referred on behalf of the applicant, subsequently has concluded that the decision of the Delhi High Court is not binding tribunal. Having taken note of the effect, while restraining ourselves from making any harsh comments, we can only say that such conduct of the members of the authority, which is discharging judicial function, cannot be appreciated. Any authority discharging judicial function is expected to maintain consistency in the use of the respective judicial matters, because any unjust deviation may affect the so-and-so. My lord, my lord, after all,
It's a observation, no comment.
my lord, your lordship is,
We have restrained ourselves from making any.
my lord, that restraining also, my lord, your lordship may kindly see, restraining, your lordship making harsh comments, and thereafter also to say that can only say that such conduct of the members of the authority, which is judicial function, cannot be appreciated. My lord, such observations, my lord, and
You just see what in one judgment is relying on that.
but that's why implies,
And another in the
no, that is not correct.
subsequent application is,
that
it is not, I'm not binding by that.
No, that is not correct, my lord. That's why the facts were not placed before your lordship correctly, my lord.
Just see the facts.
No, I am just placing before us.
Order itself is there.
No, I am just placing, my lord.
Order
The,
itself.
the judgment of the earlier judgment was passed earlier. The Delhi High Court judgment came later on. Thereafter, my lord, just 2 minutes.
They can very well differentiate by saying this, because since it is passed thereafter, therefore we are,
My lord, just,
it is not applicable in this case.
my-
It is not binding.
two lines, my lord. Let me just submit, my lord. Thereafter, the application for rectification of the mistake was filed by the applicant, and the order was passed on the section 254(2) application. Now, the Supreme Court has held, my lord, that except the jurisdictional High Court and the apex High Court judgment, the rectification cannot be done. Now, the tribunal has held that in case if a fresh proceeding in the same order, in case a fresh proceeding is there, the judgment may be applicable. But in the rectification proceedings, the appellant cannot expect that on the basis of the Delhi High Court judgment, my lord, the same.
He could have mentioned this.
Well, it is mentioned.
No, it is not mentioned.
When it mentioned, let me see.
Please.
Let me see the order.
It is not.
At page 79.
Yes.
At page 84. Para 6, my lord. The application section 254 of the Act, in the case where there is a mistake apparent from the record in the order of the tribunal, the order of tribunal cannot be assailed on the merits of the grave of the business application of the reliance in this respect can be placed on a decision of the Honorable Bombay High Court in the case of so-and-so, wherein the Honorable Bombay High Court, while relying on the decision of the Honorable Supreme Court in the case of so-and-so, further relying on the decision of the various High Courts, has categorically held the power of rectification under section 254(2) of the Income Tax Act can be excised only when a mistake which is sought to be rectified is an obvious and patent mistake, which is apparent from the record, and at the mistake which requires established. Prior to that, it has been held, my lord, at page 83. So far as the reliance placed by the learned counsel on the subsequent decision of the Honorable Delhi High Court in the case of so-and-so is concerned, we note that the said decision of the Delhi High Court is a subsequent decision of the order of the tribunal, and since the decision of the Delhi High Court is a non-jurisdictional High Court, and the same is not binding of the tribunal, however, same being decision of the higher court can be taken into consideration in deciding relevant issue in future. My lord, it was said, my lord, 254, it cannot be rectified. But, my lord, you also may see, my lord,
Sir, the earlier order,
you know,
the order which was passed prior to passing of this order of the tribunal, wherein they have relied upon the Delhi High Court judgment,
Well, that was the decision fresh case. Well, that was the fresh case.
Whatever it may be, where is that order?
What the say? No, page 86, I think, page 86. I'm sorry, 86 is the.
20.
Hmm?
20.
Yes,
20.
20.
128.
Correct, 20. 20 case case. हाँ ना, जो बिल्कुल ना.
Item number 10.
Page की मान.
22.
20. Very Williamson. Now that order, I think it is not annexed. If losses similar, I will place before lordship that order, you know. Because my issue is no, my lord, your lordship will correct in same appeal.
Sir,
You know, I'm just,
days before, relying on the same judgment, passing and after some days, he say it is.
you know, I mean, if your lordship means 1 minute will only.
Can very well, they can very well say in other words, but not in this.
But if your lordship may, just 2 minutes for my satisfaction, you know, that.
Let you just find that. 10 days.
254, the matter was 250. I'm sorry, I place before lordship. After you, you know, vacation.
After few.
Item 16.
Item 14, my lord, I beg.
14.
Item number 14.
My IA, my lord. My IA is listed, my lord.
What do you have taken?
Somebody has to be lying.
Lord, but I was not informed, my lord, and IA, my lord, is my IA, my lord. I'm just requesting if notice can be at least issued in that, because the main matter is pending, it's admitted for hearing. My lord, see, my
14.
I'm appealing for the state. Who is taking time? I don't know, my lord, the state is also here.
The state, I have also not been informed.
A for Pujari is appealing for on behalf of whom? A for Pujari is the petitioner.
He could be the appellant. I am for one of the respondents. I was not informed.
Here after 10 days like that.
Lordship, I've come from outstation. Can I request a specific date, your lordship?
Date, ask the date.
8th of May.
8th of May.
Sorry, 8th of April, your lord.
8th of April.
Item 16.
Okay, in this case, already you have issued tender and matter has been settled, lordship. They were supposed to give an undertaking, lordship. That they have not, as per single judge, or that they have not furnished. We have vacated the premises, we have issued tender, lordship. And my instruction is this, matter has been settled, lordship.
For the time being, pass over for the time being. That's great.
Item 17.
This matter is pertaining to a recovery on account of overage in service. As per lordship service book, lordship, my date of birth has been made lordship entered on the basis of an affidavit. And the respondent authority, lordship, the notice for retirement was issued on 27/6/2024, lordship, page 57.
We can do one thing.
Well,
It will ask them to initiate a disciplinary proceedings under this rule 21 of the pension rule 1969. So either they withhold your 50%, 25% pension.
Right.
And then they don't return the excess amount and suffer all this for all your life. They a pension at a less rate. It would be better.
What I'm praying, Lordship, we have to limit the prayer, Lordship, today. Lordship, and under similar circumstances, Lordship, your Lordship is aware that a writ appeal was filed.
It was 50%.
Yes, 50% was given.
No, this is not a case of 50%.
Same case, Lordship.
Not same case.
In this case, Lordship, the respondent authorities.
There was no misrepresentation and fraud on the part of the.
My Lord, the same thing was there in that case, Lordship.
That was not.
Lordship, I am giving the judgment, Lordship, in that case. Yes, yes. Just one paragraph, Lordship. Just one paragraph.
Very strange. Cousin brother has filed an affidavit, he born on so and so, date of birth change kar diya.
But they are also held liable in the impugn order itself, Lordship. Because it was the obligation on their part. That is in respect of other case. Similar issue was there in paragraph 30, Lordship.
Why you have withdrawn that writ appeal against this judgment?
My Lord,
Why you have withdrawn?
as your
Do you
Lordship,
remember?
yes, Lordship, as your Lordship was not
Because we
convinced.
said Ranit Singhal judge has wrongly asked for this only return of 50% of money. We have proposed to issue a notice why 100% recovery be not met, and then you withdraw that. What view is same? Do you remember?
Yes, Lordship.
Days before,
I have that the order itself, Lordship.
few days before.
My Lord, yes, I have that. I have that order also.
Pose you a question as that.
My Lord, I prayed for
50% recovery, we are not agreeing to it, then you have withdrawn the petition.
my Lord.
We propose to interfere with the order of the Ranit Singhal judge that 100% recovery should be.
But exactly, Lordship, similar case, Lordship, because they have.
Okay, then similar case, why you have withdrawn the petition? Still we remember,
Yes, Lordship,
we proposed.
as your Lordship was not convinced, Lordship, I like to do that.
Which one, this one or that one?
My Lord, in this case, if your Lordship kindly come to page paragraph 30 of this impugn order, Lordship, the Ranit Singhal judge, Lordship, also held liable to the state authorities that they are.
The inquiry order is there.
Yes, in this case, Lordship, that has also been annexed.
That was on the part of the, here in that case, so we took a view that 100% recovery should be made. Because in that, there was involvement of the many officials or department also.
Here in this case also, Lordship.
Here only one official, block development officer, he received an affidavit on the basis of he changed the date of birth.
But here is same thing, Lordship, same, Lordship, if your Lordship kindly come to the service book people. Lordship, service book, that is page 40, relevant, Lordship, 42. 42, my Lord.
Yes.
Here, Lordship, 1964, 0520. This was, Lordship, endorsed by the inspector.
What was the basis of this?
Yes, absolutely, Lordship.
What was the basis for this?
That was on the basis of affidavit, Lordship.
And the HLC certificate?
Cases, I have that they did not, Lordship, record on the basis of the affidavit. Cases.
It is to be recorded.
It should be, Lordship, on the basis of SSLC certificate.
That's all.
I am agreeing, Lordship, on that, Lordship.
You agree, then what remains in
Well,
this?
so far the Lordship retirement notice is concerned, that has been issued, Lordship, after, Lordship, that is page 57, saying that my retirement date was in the.
So they came to know when you yourself have submitted that certificate.
So they sought the documents, including the.
See the audacity.
Same thing,
That
Lordship, was.
you got your date of birth changed from 58 to 64. And thereafter, you yourself have submitted that certificate where my date of birth is this.
They should not, lordship, could not accept this, lordship. They have also committed a mistake, lordship. I will leave it up to your lordship, your lordship.
Up to, we are going to dismiss it with cost. This is up to them. We are going to dismiss it with cost. Not in 30 minutes. It's a person, people are asking for the government jobs, and this person for 6 long years, he remained in service.
My lord, may I
Despite
pray,
attaining the age of retirement.
my lord, may I pray, lordship? My lord, may I pray, lordship, another date may be given. I will consult with my client, lordship, another date.
You, Wednesday,
Lordship, after Wednesday, lordship, Friday, next Friday, lordship.
and then it consent to the appellant takes some time to complete his instructions
My lord,
on Friday, as prayed.
oblige.
Item 18,
Standing, standing for the standing for the
Lordship, urban counsel, Mr. HK Das is on legs, Lordship. I'm typing.
Lordship, I have a prayer, Lordship. Today, there are many cases listed on some other courts. If you can take it tomorrow or on Tuesday, Lordship. The timing will be little bit difficult, or a time may be fixed at 2 o'clock, Lordship. 2 o'clock?
We don't have any urgency. Mr. Das is not here.
Lordship, he is on legs, Lord.
Then at
Sir,
2 o'clock.
notice from your response. This punishment is somewhat harsh.
Lordship, this is a minor penalty, Lordship, without cumulative effect, Lordship.
But 3 grade in looking to conduct whatever it may be, yes, he has done, he has disobeyed the order.
Yes.
But 3.
And in fact, Lordship, Honorable single judge has already clarified.
On Archer side.
In fact, Lordship, Honorable single judge has already clarified that without cumulative effect, Lordship.
But despite that, without cumulative effect, with
There is no procedural in left.
that is our view. Otherwise, the time of a city. Okay, issue notice, Mr. So, or Mr. HK Das accept notice on behalf of the state. On behalf of the respondents. Respondent number 2, 4. How many respondents are there?
2, 3, and 4, Lord.
4, Lord.
2, 3, and 4. Who is for the state? State is a formal part, respondent number 1, state is a formal part. And no need to issue notice to respondent number 1. Learned counsel appearing for the respondent number 2, 3, 4 may file counter to the petition, writ appeal if desired so just after 3 weeks.
item 19, Item number 20.
Wait, please, Your Lordship. Your Lordship should kindly come to the rules, my lord.
Who is appealing for the state? Validity of the rule is under challenge by their counsel.
My lord, there is one prayer, my lord. Now, prima facie, I'll satisfy your lordships, my lord, why this rule 22(3) is bad.
We have already seen that. We have gone through the.
Yes, because, my lord, a promotee merely
Yes, sir.
because a vacancy arises, that cannot be the basis.
That is what.
My lord, and moreover, what they have done recently, my lord, the cabinet has taken a decision to reduce the qualifying service from 5 years to 2 years just to help these promotees, my lord. And even then they do not qualify because they earn the promotion on 6/1/23 and the qualifying service must be on the first day of January. So that way, but even then, my lord, process is on. That is our instruction. Therefore, my humble submission is, my lord,
Remain subject to the decision of the.
my humble submission is, my lord, in the meantime, they will, either your lordship fixes the matter for interim order on a particular date, or, my lord, they will not process for at least for till the next date, they will not go ahead.
I will make an observation that it will.
No, my lord, no, in that case, may I pray, my lord? Lordship will keep the matter for interim orders on a particular date, let state file whatever affidavit.
Process of selection.
No, my lord, why I am saying so, why we are saying so, my lord, when they do not have the qualifying service also, apart from this. If your lordship should,
So that you can very well challenge by way of.
no, I am only saying, my lord, respondent number 3 to 98, not against others.
Essentially, sir,
Yeah.
repetition, you have challenged the validity of the rule.
Yes.
That's why only it is before the division.
Yes.
Otherwise, you can very well, if they are having the.
My lord, if your lordship should kindly permit me to place one judgment, my lord, 2020, 1998 4 SCC. My lord, Jagdish Patnaik's case. My lord, normally the rules are, if in a particular year, both direct recruitment and promotions takes place, my lord, in that case, promotee will rank senior. But our rule is, my lord, as far as promotee is concerned, what is relevant is the occurrence of the vacancy.
In fact,
Yes.
I forgot the judgment of the Honorable Supreme Court where which we have also decided we are going to search it.
Yes.
Wherein the Supreme Court has said okay, the seniority will recon from the date of the. vacancy.
Entering in, my lord.
From the date of vacancy.
No, my lord, Supreme Court has discarded that. I'll place that at 2025 SCC.
Meg Chandra or something, that judgment was Meg Chandra.
Megha Chandra 2025 SCC.
It has been.
Yes.
The.
That Manipur case, my lord.
Yes.
Yes,
Yes.
their Supreme Court says
My lord,
the safest course is to take note of the fact when one enters the cadre.
My
Because
lord,
arising,
This has also been referred to the larger.
yes, in
No.
her, yes,
My lord.
Mega Chandra has been referred
My
to
lord.
like a pension ideal.
no, my lord. Even if a reference is there, my lord, until and unless it is overruled, Supreme Court has time and again said that decision will prevail. Now, for example, if your lordship could kindly come to para 24 of this Patnaik's case, my lord,
Yes.
where the rule which was under challenge, for consideration of the Supreme Court, page 464. Seniority. When officers are recruited by promotion and by direct recruitment during the same year. Normally, my lord, this is the rule. Now, please come to the impugn rule, my lord. Impugn rule.
Impure rule says that the officers who are.
When the vacancy arose. Yes, no, my lord, vacancy.
Their seniority will recon from the date of vacancy.
Oh, yes, please come to page 220, my lord,
Yes.
where we have annexed the rule.
That is the member
Yes.
appointed by promotion against the vacancy of.
Occurring in a year.
shall be senior to the member of the direct recruitment. and
of that year.
Irrespective of the.
My
date
lord,
of appointment.
vacancy may arise until and unless under the relevant rules, the select list is approved and an appointment is made. Where is the question of he becoming a member of the service? That's the point. My lord, I have made one submission.
Just
If your lordship would kindly come to page 38, my lord,
yes,
para 21.
yes.
That the impugn rule 22(3) is in conflict with rule 2J, rule 61A, rule 61D, rule 13 and 11C read with article so and so. Impugn rule envisages a situation wherein a promotee is entitled to count their seniority based on occurrence of vacancy in a year while a direct.
Suppose a vacancy occurs in the year 2021 and for whatever reason the promotion exercise carried out in 2026.
Yes,
In between many direct recruitees.
may have come.
Then also.
Yes.
they-
No, my lord, no, my lord. As far as promotee is concerned, there is a requirement under sub rule 6 of rule 13 to approve the select list.
Then only.
Only when his right crystallizes. Now, my lord, now rule 22(3) is directly in conflict. That means you are giving seniority from a date when you are not even born in the cadre, retrospective promotions with Supreme Court. So therefore, I am saying, my lord, let them not promote respondent number 3 to 98, not others. Yes, that's why I said, my lord, lordship may keep the matter for interim order on a particular date.
I am preparing for the caveators, but now I am preparing for the all the private respondent. As your lordship has proposed at the first instant, my lord, one of the rule which have been put into challenge here has gone to the Supreme Court also. Then the Supreme Court says that we, however, make it clear that any promotion if made pursuant to the impugned judgment shall be subject to the final outcome of the special leave petition. So that is what, and my lord, I don't agree with the
Supreme Court.
it is pending.
This very
Not this very rule, another rule. My lord, so I am saying that so far.
Another rule.
So if as your lordship has proposed that if it is subject to the result of this writ petition, we have no objection.
You are appealing for the private, who is appealing for the state?
1 and
1 and 2. Okay. My lord, that's why I was only praying, my lord, let for interim order, did the matter be fixed on another date, we'll make our submission.
Mr. Naik, accept notice on behalf of the respondent number one. Mr. Kumar is acting on behalf of the female private respondents.
3 to 92 and 94 to 98, except 93.
Why?
93, my lord, he is from a different retired. 93 is retired and 99 is, I'm not appearing because his channel of entry into the service is different.
My lord, actually, he was on acquiring that qualification, he was promoted.
However,
See,
it is informed that respondent number so and so is retired.
94, 93.
Four is has already attained the age of superannuation. Stop. In such circumstances, since he has already attained the age of superannuation, at present, no notice is issued to the respondent number 94,
93,
90, 93 or 94?
93.
93. Learned concept for the state as well as the private respondents have granted time to file reply to the counter to the writ petition.
We have already filed our reply.
You have already filed.
Yes, yes, madam. Because this matter came up before the learned single judge, we have.
State, learned concept of the state is granted time to file reply. This petition on 23rd of April.
for my lord, consideration of the interim
It
relief.
is understood, sir.
The lordship will still indicate, my lord.
It is understood, sir. We'll consider it.
My lord, may I
Or
pray,
we'll hear, if possible, we'll hear it finally.
my lord, may I pray,
On that day, the reply of the state will
The
come.
lordship will give us the liberty to renew that prayer, my lord.
So anytime you can.
Yes.
my lord, may I
No.
pray on 25th of April?
Renew.
25th of
I
April.
took only here the life ago. We have already
Yes, Mr.
paid.
Chaudhary, 25th of April, is
No problem, no problem.
25th of April.
Deeply obliged.
Item 22.
Here, imping judgment is dated 6/4/2023 in OA 5 of 2021.
Somebody took adjournment in
My lord,
22.
similar to this, my lord.
Same to continue, others change. ये नंबर कौन OA number. Why don't you amend the जो OA number है वो लगा के दो.
My lord. Hello, my lord.
Item 25.
Next. Well, this is a PIL.
Make your own bed.
Well, this is a PIL referred by.
Yes.
Well, this is a PIL preferred by a few active people who are active in public domain or belong to Tiwa community, my lord. We allege, my lord, certain discrepancies in the work orders, my lord. My lord,
Misappropriation of fund and
yes, my lord.
corruption and
But
embezzlement.
my lord will kindly come to page 29. 29, the price of the cycle, just for example, my lord, the price of a cycle is 15,000.
the committee has approved, whereas Lordship will come to page 32. The same cycle, my lord. The petitioner went to the market. The same cycle is only 5,780 rupees. Likewise, my lords, the orders were passed for yarn, my lords. Yarn they are giving for 1,100 rupees, my lords. But if you go to the petitioner went to the market, bought the same yarn at the price of 500. And also, my lord, the pump sets, my lord, they have 31 at the rate of 31,600 rupees, my lord. But the same pump set, my lord, is available in market for 1,100 rupees. And I have prepared, my lord, the representation before the DC, SP, and the Chief Secretary, my lord. And this is not the first time, my lord. This is counsel from the beginning of inception, my lord. It has what it has done, my lord. It has only done, my lord, decentralization of corruption, my lord. Earlier, there is also like charges, my lord, FIRs pending, my lord. The case is pending. My lord, kindly issue notice.
What do you want?
My lord.
What do you want?
Well, I just want my lord issue notice. My lord.
No, you want to ultimately what belief you are saying.
My lord will issue a notice and my lord direct investigation. My lord, why they have gone to this kind of
Approach the competent criminal court for that.
my lord.
Approach the competent criminal court.
Well, we have
File a complaint.
well, we have preferred before the DC, SP, and the Chief Secretary. My lord, they're sitting over it, my lord.
Any person files an application or a complaint with the police officer, SHO, or the superintendent of police, if the FIR is not registered, what is the remedy available to?
And then I can go to the magistrate.
Go to the magistrate.
No, my lord, this is had been, my lord, this is a single isolated incident I could have preferred, my lord. But this is happening again and again, my lord. My lord, I have demonstrated.
You are alleging
I have alleged and I've demonstrated, my lord.
You
My
are
lord.
alleging corruption, misappropriation of funds, government money, public money.
My lord.
Go before the court, then take the cognizance.
Well, look, I have also annexed the minutes which they have approved, knowingly they have approved, and I have demonstrated the variance in price, my lord.
We are not doubting whatever the
My lord.
allegations you are leveling. Maybe the allegations are true, but go through the process. Why this PIL?
PIL, my lord, I will be very true, my lord. All these are powerful people, my lord. Because earlier that's my lord, and the other session also, my lord, this is this.
Against in a court of law, what is the powerful or what is not powerful?
Well, the earlier FI also, same incidents happen, same kind of incidents, my lord. It is not reaching to its conclusive end, my lord.
That's another thing. Then in that also, the complainant has a right to approach the court.
Yes, in paragraph 6, my lord, I have seen, my lord, is to the PS case of 266 of 2018, my lord. From 2018 also nothing happening, my lord. They are repeating the same offense again. Same cycle goes on and on. The same cycle goes on, my lord. I'll go to file a case. Nothing will happen, my lord.
In such type of cases, the Supreme Court has said, instead of interfering or issuing any writ of mandamus, the person should be asked to oppose the criminal.
I appreciate that, my lord, but in certain other cases, the Supreme Court has said, my lord, that court can interfere, my lord.
In the recent 2023 judgment also the court has said.
My lord.
Three judges went of the Honorable Supreme
My lord.
State of Jharkhand versus Shiv Shankar.
But if my lord gives a direction that we may approach and the police may register, my lord, that will also suffice.
Sir, who is preventing you? Why are you waiting for our direction?
My lord.
Why are you waiting for our direction?
My lord, because if lordship doesn't direct anything, my lord, at page 9, the criminal case, my lord, same issue, my lord. I've said nothing has happened to this case. It's hanging. No charge sheet, nothing, same kind of allegations. Only articles are different and session of that committee was different.
This para number 13. PIL.
Already. Sixteen will suffice. What? 16, paragraph 16 of this order, man, conclusive paragraph. It will serve my purpose. But Lordship will refer to that Shivdev Singh's case, man.
Why?
At least that, man. I'm just asking 2 paragraphs, man.
Okay. Here the petition is filed by this. Petition seeking the following. Prayers. Page number 70. Praying for granting the following readings. Having gone through the contents of the PIL and the material available on record, we bear of the view that all acts which the petitioners have highlighted in this PIL petition are essentially acts of corruption and embezzlement, which fall within the definition of relating to be offensive under IPC and now Bharatiya Nyaya Sanhita, or are acts of criminal misconduct under the provisions of the Corruption, Prevention of Corruption Act 1988. Para number 12, 13, 32.
Publish minutes.
Item 26.
Please, Lordship. You're covered.
Memo appeal is yet to serve upon us.
Oh.
Only IA, office of the IA.
আজি তো ইনক্লুড কৰা
Yes.
Lordship, we also have not been served with the copy of the written.
Yes, my lord. Here is a, my lord, we have come against the impugned judgment dated 12/5/23, passed by the Honorable Single Judge, page 43, man.
You were party to the petition.
No,
So
We're not-
before challenging the impugned judgment by way of writ appeal, have you sought any?
yes, my, yes.
Have you sought any leave from this court?
Yes, my lord, we have filed also impleadment petition also in the writ petition.
Impleadment petition. You're challenging the judgment of the state court,
Yes, my lord.
then you have to seek a leave from this court to file in this writ appeal.
They may be allowed to file the leave, my lord, leave appeal.
And how you are agreed with this order, sir?
Yes, my
By
lord.
the Learned Single Judge order, how you are agreed?
Because I have been, order has been passed to initiate the proceeding under section Rule 18 of Assam settlement rules, my lord. And thereafter, my lord, the settlement rules, my lord, the law has come up now, the recently reference court has made that the bona fide claim of right to be examined by the deputy commissioner.
So
That has not been examined.
come to para number 9 of the impugned order.
Yes, Rule 18. That is Rule 18. Yes. In view of Rule 18, Assam Land and Revenue Legislation, and keeping in view of the fact that construction has been made on public road which is being used as a public road, the response number 2 and 8 are directed to necessary action against the same, keeping in view the physical verification made by light model. The entire exercise should be conducted by the authorities within 2 months from the date of receipt of certified copy of this order after giving notice to the new occupants therein.
You are the new occupant.
Well, I have not pleaded in the writ petition, my lord. I have not impleaded. I have not.
Learned Single Judge has said.
No. They say I am the new occupant. Even new occupants also, my lord, notice was to be issued.
That's what the Learned Single Judge has said.
No.
No.
Honorable single judge has held on the basis of para 8, my lord. Para 8 is the, my lord, the report of Lat Mondal.
So that report is not correct.
May not be not complete. May not be not correct. That is to be examined by
May
your lord.
not be or not correct. May not be. May be.
Not correct. As
May
per
not
me.
be, may be.
Yes, as per me, it is not correct.
Not correct, then show it to the authorities concerned who are going to evict you.
That is the thing, my lord. That is the thing that they have issued after that the eviction notice has been issued.
So approach them and say, I have these genuine documents, I am not supposed to be vacated.
That is not
I am
done,
not
my
an
lord.
encroacher over the
No.
land.
That is not done, my lord. By virtue of this
Not
order.
done, that is that is altogether a separate cause. File a fresh writ petition for that.
No. That writ petition I have filed.
You have filed.
No, I have filed.
Then?
That was dismissed. No, that was dismissed. No.
Only now
My lord,
you have filed this writ petition.
no,
prior to
against the
filing of
eviction
this.
notice.
Huh?
Against the eviction notice, my lord.
Eviction
And
notice.
eviction notice.
Why the petition was dismissed?
No, that writ petition was dismissed on the ground that whatever the land I have applied for,
Huh.
that was not correct. But this is not the land. The writ petition, which was dismissed, we had said that our number was wrong.
Mr. Counsel, just
Yes, my lord.
pursuant to this impugned order passed by the Learned Single Judge, a notice was issued to you.
No, yes. Notice, eviction notice was issued to me.
Eviction notice was issued to you,
Yes.
which you have challenged before the writ court,
Yes,
and the writ petition has been dismissed.
yes, dismissed.
What remains?
Well, that petition, that,
How now you can challenge this order, sir?
no, because here
That has been acted upon.
Here in this case, I was not made a party.
Again, you are sticking to that.
Sorry.
There is the question of making you a party.
Now, because my lord, why it is not correct?
So they simply came before this court, they look in front of our house, there is a public land where some illegal occupants or some persons have encroached the government land, public land.
Yes.
Please issue a direction to the authorities to remove those encroachments
yes,
from
my
the
lord.
public land. That
Yes,
is what
my
that was the case.
Yes, my lord.
Learned Single Judge sought some information
But
from the revenue authorities. They after inspecting, they said yes, there is a encroachment over the public land. And the Learned Single Judge simply said, remove that encroachment from the public land.
my
And
lord,
any other person is sitting there, give them a notice.
alternatively,
remove
yes, I agree with your lordship, my lord. Alternatively,
The authorities concerned gave you a notice, eviction notice, saying that you are you are the encroacher over a government land, against which you file a writ petition. That writ petition was dismissed. Now you are challenging this order, sir. What is the?
No, this was challenged before that, my lord. This
Okay,
was there.
before that, after that, that writ petition was dismissed. That
Because
is also
eviction-
very material and relevant.
Now, just one thing is to be examined here, my lord. Now, whether 18.2, Rule 18.2 of Assam Land and Regulation can be acted upon on the basis of a complaint made by the private person, my lord. Whatever we have come that if the government land is occupied by someone, eviction process normally issued by, initiated by the government authorities, land revenue authorities. But here on the basis of private party, Well, here the question is that eviction notice has been, process of eviction notice has been initiated by virtue of a process made by the private party. Normally, we know that if I occupy a government land, normally from the end of the respondent's government side, initiation of eviction notice issued. Now here he has made a complaint before the district authority that in front of his land, government land is there, I have occupied that land.
Who is going, otherwise, who is going to make this complaint?
Yes, my lord.
The person agree.
Yes, I agree with this. Application has been made, but what is
You are
whatever?
agreeing with everything.
No,
But
that
again, you are
obstruction will be removed by whom, my lord? No, that obstruction will be removed by whom? 133 CRPC applies, my lord. Here nothing has been done. Directly they have come to the writ court. 133 notice, CRPC notice that I have obstructed.
How 133? That is in relation to public nuisance.
Public nuisance, my lord. Here,
Encroachment over the government land is
here,
altogether different. It's
my
not
lord, kindly look into his complaint then. His complaint, nothing, because I have obstructed, he has occupied a land, I have obstructed him in front of his land, my lord. So that is my lord, the grievance, whatever his grievance is before the.
No, sir. He has not said you have encroached over in.
No.
He said some persons have encroached.
Yes.
from whom you have purchased this land.
Yeah, kindly your lordship may go into the complaint made by him before the deputy commissioner. Before the deputy commissioner, simple complaint, actually a proceeding under section 133 CRPC. But there, in spite of doing that, writ petition has been initiated.
Yes.
So, my lord, here, by that eviction process, actually, in the bona fide right, if we go the revenue law, my lord, bona fide right of claim is to be examined.
Okay, when notice was issued to you for this eviction or whatever under section 18, when notice was issued to you?
That I have to, my lord, because there's already, I have to, my lord, collect the document, my lord. Now I am not ready.
The writ petition which you have preferred before the learned single judge. which has
No,
been
that was,
dismissed?
that I have preferred, I have already.
2023, my lord. 2023.
What is the number?
4082, challenging the eviction notice dated 10/7/2023.
10/7/2023.
My lord, it's a pleading in a section 5 petition. Section 5 limitation, para 5, my lord. IA, my lord, 3661.
Record at present, I don't have, my lord.
Only pleading is that writ petition is impugn or notice is stayed. But my learned friend already has submitted, my lord, that has been dismissed. Para 5. Page number 8. Okay.
Yes, sir. Yes.
My lord, that requisition was dismissed on the ground there. Bosundara, I have applied, I thought that my plot number is so and so. Then in the inquiry found that I have given different number. On that count, it was dismissed, my lord, requisition. Now here, what I find is that an application has been made by the respondent, this private respondent before the deputy commissioner that front of his land has been obstructed. I think 133 proceeding lies, but it was not drawn, my lord. Directly writ petition has come and writ petition has been heard without me, my lord, and it has been disposed of. So we have now filed the appeal, my lord.
That was it.
Yes, my lord.
This writ appeal is filed on behalf of the petitioner, being agreed with the order dated 12/5/2023 passed by the learned single judge in WPC number 15715 public 2022. Stop. The writ petition number 5715 public 2022 was preferred on behalf of petitioners Badrul Islam, petitioner Badrul Islam, alleging that he is a recorded patadar of plot of land measuring 1 katra 5 lechas covered by duct number 4534 of KT Patta number 2985 in bracket new slash 111 in bracket old of revenue village Hengbari Moja Beltola district Kamru. He has raised a grievance that the respondent number 11 and 12 in the writ petition took advantage of the absence of the petitioner and forcefully occupied the land in front of the petitioner's land, which is being used as public road, thereby blocking the ingress and egress of the petitioner's land. Full stop. Pursuant to the notice issued by the writ court, the respondent state has filed an affidavit in opposition wherein the fact regarding the encroachment over the public land in front of the petitioner and the writ petition, in that writ petition has been has been substantiated. Full stop. Taking into consideration the Lat Mandal report, the concerned Lat Mandal report and the other material available on record, the learned single judge, while order dated 12/5/2023 has disposed of the writ petition number 5715/2022, while observing that keeping in view of the fact that the construction has been made on public land as per Rule 18 of the Assam Land and Revenue Regulation 1886, the respondents, the state authorities are directed to take necessary action to remove the encroachment, remove the aforesaid encroachment from the government land, from the public land. It is further directed that the entire exercise should be conducted by the authorities within 2 months from the date of receipt of certified copy of the order after giving notice to the new occupants therein. It appears that pursuant to the said direction given by this court, and notice was issued to the applicant on 10/7/2023, and the appellant immediately has filed an writ petition number 4083/2023, assailing the validity of the said notice. Full stop. That writ petition ultimately came to be dismissed on 1/10/2024, upholding the validity of the notice issued to the
My lord, they are just,
appellant herein.
my lord, interim order passed in that writ petition, my lord.
Ultimately dismissed.
No, my lord, eviction was stayed. Then private respondent come up with a vacating petition, my lord. Vacating petition was allowed. My stay order was vacated. Immediately next day on the vacating petition, prior to dismissal writ petition, I was evicted. But
That's another thing. Full stop. Now, the petitioner is assailing the impugned order passed by the learned single judge on 12/9/2000, 12/5/2023 by way of this writ appeal. Full stop. It is also to be noticed that before filing this intra-court appeal, the appellant has not moved any application seeking leave of this court for filing the intra-court appeal. Apart from that, once pursuant to the impugned order passed by the learned single judge on 12/5/2023, an eviction notice issued to the petitioner has already been upheld by the writ court of this court. No case for interference is made out, hence this writ appeal is dismissed.
Item 27.
May it please your lordship.
Brother is having some difficulty.
But we are, what my lordship has passed that order, we are praying for the same order only here. And I don't think it will be
Brother is having some reservation.
no difficulty, lordship.
Another bench.
Maybe could be on, in fact, that order which is beneficial to all the sides. That order we are trying to enter.
So I don't think from both sides there is any objection my lord would consider because we will leave it.
One of the member is not come.
We will leave it. We will leave it.
Not in.
But we have instructions to appear in this case where the writ petitioners, a copy of the memo of appeal can be furnished first.
No difficulty, lordship. Only thing that could it be taken up on Monday because we do not Tuesday.
You make a request, I'll ask.
Lordship.
I think, my lord, there is some confusion regarding Tuesday also, my lord.
Because
that is in with the
citing of the moon.
visibility of the moon.
it will be either Monday or Tuesday, one of these days.
And then Tuesday.
We can.
In that case, let it be on Wednesday, lordship, comfortably.
Make a request to the registry and.
Lordship. Highly obliged, lordship.
Item 28.
Deep blue, huh?
Please.
Yes, who is appealing for the respondent?
Yes, but I'm appearing.
All the respondents.
Yes, but all the respondents.
We like to file some
Yes, but we'll file.
counter
Yes, madam.
notice. Mr. So and so, accept notice on behalf of all the respondents, which will therefore come. It takes some time to file counter to the jurisdiction, time frame for is granted.
What date, my lord? See, it's 81 years, my lord.
May any day.
Item 30.
Already ordered plus my lord application.
Which one?
Honorable Supreme Court has passed the order.
We have, on administrative side, we have also passed.
My lord.
My lord,
On the administrative side, we have also passed.
my lord.
My lord.
Para 4, my lord.
Yeah, that is, after taking into this,
My
we
lord.
have already passed it. That, all the bail.
All matters, yes, trial, everything.
They would be considered before that.
My lord.
Deep lord. Let me close my.
Can you close this application?
In view of the order passed by the Honorable Supreme Court and special leave petition, civil diary number 1906 public 2023. Order dated 17/3/2025. And in view of the order passed by the Guwahati High Court on administrative side, this writ petition has become, this writ petition is closed.
Deep lord.
Item 31.
Yeah, you, talking on the क्या लिखा है पहले वाला? The administrative side, the main applications preferred on behalf of the aggrieved person in Manipur violence cases trial of which is being conducted by the Guwahati courts. The क्या लिखा है? Fee of that or performance of? Are to be considered and adjudicated by the Guwahati High Court. This petition is closed.
May it please the lordship. My lord, first lordship, the rule has been said as Assam State Prosecution Service Rule 2023. Now by these rules, the provision of act has been sought to be taken away. Lordship will see 24, section 24 of the CRPC, that is the act of parliament. Now by these rules, the provision of act has sought to be amended.
How?
Yes, madam. Because earlier, there were public prosecutors, additional public prosecutor, assistant public prosecutor. those who were appointed in view of section 24 of the CRPC.
Where is that? Now by section 24.
Yes.
The new provision under the BNSS?
BNSS, my lord, this is 23, so at that time that did not come. So, my lord, first question is this, whether by subordinate legislation, can the provision of act can be taken
Shows
in?
the provision of the act, sir. Shows the provision.
Yes, Lordship may kindly see section 24 of CRPC.
Yeah. Yes, we.
My lord. For every high court, the central government or the state government shall, after consultation with the high court, appoint a public prosecutor and may also appoint one or more additional public prosecutors for conducting in such court any prosecution, appeal, or other proceeding on behalf of the central government or state government as the case may be. So, the provision is laid down under section 24 of CRPC. My lord, this is the act of the parliament. Now, by the rule of 2023,
Yes, sir.
yes, my lord. Now, so this is very much clear that by subordinate legislation, the provision of the act cannot be overruled. That is one aspect of the case. But my lord, I am not so serious on these amendments or the proposed amendments sought to be to be applied for the appointment of new public prosecutors, additional, etc., etc. My submission is this, my lord. Since last 23 years, I am public prosecutor. There is no single complaint against me. Now the proposed amendments of these rules.
Amendment the new rules at all. Amendment
My lord?
It's not amendment. They have constituted they have enacted new rules.
No, amendment is also there, page 28, Lordship may kindly see, page 28. Some amendment has been also made. The Code of Criminal Procedure, Assam Amendment Bill 2022. So, my lord, what? The Supreme Court, my lord, there were several cases in similar matters. The Honorables, I have given the citations also. The Supreme Court has said that what cannot be done directly, that cannot be done indirectly. And there is some direct discrimination, there are some indirect discrimination.
Just to answer where this section 24 prohibits the state government to frame rules. Where is that?
No. At present, I am the rules of 2023 rules only.
But
So
these
that's,
rules were framed. These rules are framed while exercising the powers under section 24 and 25 of the CRPC.
yes,
So you are saying that when this section 24 says that how the public prosecutors are to be appointed,
yes.
the state government cannot introduce a different mechanism from that which is repugnant to section 24. How it is repugnant to 24, such section 24?
Now,
And
then
now
Lordship,
you are praying that since you are working from last so many years, some preferential treatment should be given to you. Approach the state government by filing an appropriate representation. They'll consider it if they're bound.
yes, that
Your-
there is also such provision in this. Lordship may kindly see page 27.
27.
Yes. Relaxation in the condition of services.
Yes.
Where the state government is satisfied that the operation of any rule regulating the conditions of service of persons appointed to the service causes undue hardship. In any particular case, it may notwithstanding anything contained in the rules applicable to such cases, by order dispense with or relax the requirements of that rule to such extent and subject to such condition as it may consider necessary for dealing with the case in a just and equitable manner. So there is a provision.
So approach the government. They'll in discretion, if they in its discretion, they'll find, okay, yes, we have to relax the rule, then relax the rule.
Then Lordship may kindly dispose the matter by observing that provision.
What observing that rule?
Here this is there. So your observation would be beneficial for me. My lord, I am in the age of 61 years. My lord, there are some honorable Supreme Court has made some.
After attempting to argue the matter for quite some time, Learned Counsel for the petitioner on instructions has submitted that he wants to withdraw this petition with liberty to approach the state government to relax the rules of relax the applicability of the rules of Assam state.
Assam State Service Rules 2023.
Assam State Service.
Prosecution, sorry.
Prosecution
Prosecution Service Rules 2023.
23. In the 2023, in the case of the petitioner, stop. Dismiss with liberty as prayed for.
My lord, dispose lordship may kindly observe. Dismissal may bring some misery to my life.
What like to your life?
To my life, miseries may brought. So dispose of lordship.
Okay, disposed of.
And they may consider within a time, my lord, that lordship.
And will also pass an order and they should appoint it.
No, okay.
And what else? Consider and all.
Pass over matter 16.
When present on behalf of the appellant, even in second round, dismissed for non-prosecution.
For hearing, item 24.
Please, your lordships. Because in the meantime, the appellant has retired from service, and the my lord private respondent also my lord attained the age of superannuation prior to age. The appellant my lord retired on 1st of June 2024, and the respondent number 5 attained his age of superannuation on 6th of March 2023. Now, my lord, the only thing that remains is that my lord, because he challenged his order of removal from service, and the education tribunal eventually said that removal is bad. Then, my lord, the honorable single judge has also, my lord, approved that. Now, the only effect, my lord, that only part that may affect both of us is that, my lord, so far as the appellant is concerned, his pension may be affected.
How?
Because, my lord, the order of the honorable tribunal, my lord, if your lordship kindly sees the operative part, that, my lord, after the dismissal of the writ petition, that, my lord, remains, that your lordship will find at, my lord, page 196. 196, it starts, my lord. The operative part, your lordship will find at page 218. Paragraphs 32, 33, and 35. Paragraph 32, my lord. In consequence, may I read it, my lord? Page 218, paragraph 32. In consequence, my above findings, by setting aside the resolution number 3 by which the service of the petitioner, Ramanan Jha, was terminated as illegal, the consequential actions taken, that is approval of Avadesh Kumar Singh, that is the appellant, as headmaster also held to be illegal and liable to be set aside, which I do accordingly. So far as the further relief regarding direction to the official respondents to provincialize the service of the petitioner as headmaster of the school with effect from 1/1/2013, I am of the considered opinion that it is beyond the competence of the tribunal. The district level scrutiny committee, as contained under section 10 of the Act, since repealed, the same is an independent body having its own power to scrutinize each and every case on the basis of eligibility of a particular person for getting his service provincialized. The tribunal can only refer the matter for consideration afresh by the district level scrutiny committee. Then your lordship can come to paragraph 35, my lord. The petitioner is entitled for reliefs as follows. Number one, resolution number 3 dated 22/8/2007 is illegal and accordingly set aside. That the termination of the petitioner from service of Bapuji High School Hindi Medium by the resolution adopted by the school management committee dated 22/8/2007 is hailed as illegal. The consequence thereof, the appointment of the respondent number 4 as headmaster in place of the petitioner is also illegal. That is, my lord, my appointment. So far as the provincial of service of the petitioner, this district level scrutiny committee Morrigaon shall consider. Petitioner is entitled to for subsistence allowance for the period under suspension if not paid by the school management committee for the period of his suspension. Now he will be entitled to the, my lord, the subsistence allowance.
And it's not going to be affected your pensionary benefit.
That is only apprehension, my lord.
That is not going to be affected. Yes.
Here, my lord, the party is retired from service.
Retired from service?
Yes, my lord.
So nothing.
My lord, now my full submission before your lordship, learned tribunal set aside his appointment and said that resolution number 5 is illegal.
Yeah.
That also set aside. Now your lordship, honorable single judge also upheld the judgment of the tribunal.
Fine.
Now it is in appellate stage, my lord. Now it is said that all are retired. So, my lord, my humble submission before your lordship, we retired, no doubt. But whether any illegality committed by the tribunal or any illegality committed by the learned single judge.
Since you both of you have retired, we'll close this matter.
No, my lord,
Then and there.
your lordship is to give finding whether that order is valid or not.
There is no jarut.
Yes, that is necessary, my lord, because
Dismissal of the this writ appeal on the ground that both of you have retired.
Yes, my lord.
So that amounts to confirmation of the order passed by the learned single judge. That amounts to affirmation of the order passed by the learned single judge.
I could not follow, my lord.
Since both of you have retired,
Yes, my lord.
and after observing this, if we dismiss or dispose of this appeal
Yes,
only on this ground, since both of you have retired,
my lord.
no further order is required to be passed or no further adjudication is required,
My lord.
which means that the order passed by the learned single judge is affirmed
Yes,
or not.
affirmed, my lord.
So then how you are
My lord,
having any
here-
grievance
here-
about that?
Here, your lordship, that land, judgment of the learned single judge upheld. Now, your lordship would be pleased to see, I am referring to judgment, my lord, of the
Sir,
Honorable
it is
Supreme
not
Court.
your appeal.
My lord.
Is it? It is not your appeal. You have not challenged the order of the learned single judge.
No, no, my lord, learned single, order of the learned single judge, that is in my favor. That is in my favor, how I will challenge it.
So
No
now,
question. Now, my lord, my humble submission before your lordship, I am just referring one Supreme Court judgment, my lord. Here, Honorable Supreme Court, I am fighting the litigation from 2007, my lord.
yeah,
And ultimately, in all round, I won the case. Now we have retired. Now, Honorable Supreme Court, in this judgment, my lord, held like this, that if a person even retired during pendency of the litigation, then also he is entitled to some benefit. That is
sir,
the
is it
judgment.
not your, it is not your appeal.
My lord,
How can we pass an order in this appeal?
no, my lord, in that case, my lord, that appeal may be dismissed.
So what we are doing,
My lord,
what we are doing,
my lord.
what we are
No, my
doing.
lord, your lordship just see the judgments, my lord.
Sir, why we see this judgment? It is not your appeal.
My lord.
His challenge to the impugned judgment is not accepted. How you are going to be affected with that? And in this, his appeal, how can we direct payment of salary or whatever the benefits to you, sir?
My lord, my humble submission before your lordship, I fighting the litigation from 2007. Now what will happen, my lord? That writ appeal is dismissed. Writ appeal is dismissed, I will not get anything.
So what, हम क्या करें अगर नहीं मिलेगा तो? What can we do? We are simply not entertaining this writ appeal, that's all.
Yes, ma'am.
So consequential will follow, the consequence will follow. Mr. N.K. Chaudhary, senior advocate, appearing for the appellant, has submitted that since the appellant as well as the contesting respondents both have attained the age of superannuation, nothing much is required for adjudication in this writ appeal. In view of the above, nothing much is required for adjudication in this writ appeal. Learned counsel appearing for the contesting respondent as well as the state are not in position to dispute the fact that the appellant as well as the contesting respondents have attained the age of superannuation. In such circumstances, this writ appeal is closed, dismissed as the writ appeal is closed as dismissed.
Obliged, my lord.
Item 26.
Wait, please, Lord. My lord, here the appellant FCI framed a scheme, my lord, by which, my lord, the employees are given one increment for good conduct, good service record for the last 8 years, provided that
No such adverse.
nothing adverse and no defeat pending and no penalty suffered. My lord, the petitioner, the lead petitioner became entitled, my lord, entitled, and on the date of his entitlement,
Who is for the other side?
my lord, we have twice taken, my lord, Dasti service.
No, no, no.
No, it's a period. Otherwise, my lord, after the penalty, he was given twice.
Yes.
My lord, the single judge, my lord, your lordship will kindly have a look at the relevant circular. Yes, your lordship will kindly come to page 36. Lordship, the conditions are the employee who have reached the maximum period so and so on. Second condition, there should not be any vigilance case pending against the official, or the official should not undergo any tenure penalty or at the time he or she was eligible for grant of stagnation increment, which could not be granted so and so. No vigilance case is pending against the or contemplated on the date. So and so, my lord, on 29/9/95, the memo of charge was issued against him. Ultimately, my lord, penalty was issued, my lord, penalty order was passed on 16/1/1998. So after 1998, he was given twice, my lord. And on 1998, he could not be, I mean, on the date of his entitlement, he could not be given because initially the DP was pending, which finally ended with the order of penalty. So under the provisions, we could not provide him. But your lordship, kindly have a look. The order of the landed single judge, my lord, held that there is nothing in the circular of 1999 by which my lord, diverse one to get the benefit. Lordship may peruse page 85 with the speaking order.
96 May, you have granted an additional increment to him.
No, no. He became entitled. We did not grant him.
When granted?
And we did not grant him because of this, my lord. Because it was initially, the general office initially passed an order with such conditions.
So why the order of recovery if you have not granted it?
No, no, we have not, there is no recovery, my lord. We have not granted him.
It's there, sir.
Huh?
You are ordered for recovery.
No, no, we have not, my lord.
But it is there.
He is claiming that, my lord, he was not given. We have not passed any order of recovery.
Cancellation of the without aiding the petitioner letter dated issued by the Silchar for recovery of the amount towards the additional increment granted to the petitioner with effect from itna without hearing the petitioner in this case.
Which, my lord, your lordship is that?
Sir, internal page 3
Of
the judgment, sir. Clause 4. By way of the present petitioner has challenged the following orders, letters.
My lord will kindly have a look at the read petition. The read petition prayer. He has not prayed for recovery. My lord, there is no recovery, in fact. Read petition for you.
But, number this just internal page 3 of the judgment.
My lord will kindly see prayer of the read petitioner.
Sir, what do you, sir? Letter dated 19/4/2010, annexure 11. What is the annexure 11? The writ petition.
I'll take your lordship to that, my lord. 19/4.
19th of April 2000.
My lord, the order which is put to challenge is at
Please find here a copy of letters received from so and so, regarding rectification of additional increment in respect of Shekhar Kanti Dev, Silchar manager so and so, Silchar, and therefore requested to take necessary agreement about letters.
page, my lord, 85 is the impugn order. Page 85. His prayer is to grant additional increment, not recovery, my lord. He did not come for recovery, against recovery. Page 60 is the prayer. And impugn order, page 85. No, it was not granted, my lord.
It was granted, sir.
My lord, in fact, the order was passed.
And the additional increment granted earlier from the actual date of joining in the post by the office.
No, my lord.
Giving an effect from is also
My lord.
entitled to fall within the intervening period of vigilance case. It is therefore request kindly take necessary action and implement.
No, my lord. The granted that I've read earlier, my lord, it was the order passed subject to. Then the regional office said he wanted to grant. It was not granted, in fact. Nobody was granted by that order. My lord will see the prayer.
Final,
Page 85, my lord, kindly have a look. Page 85.
85 we have already seen.
My lord, this is the order passed which was challenged. He was not granted. So we could not be granted because he suffered a penalty.
No, you just make a statement whether you have actually paid him or not.
So we can make a statement.
You can make a statement and Mr. Roy, please type once. Whatever the sanction, even not grant, the sanction of the additional increment was made, in the year 1997,
1999, effective 97.
97 and later on 96.
That was for all, not no, for all.
96 or 97.
Yes.
Now you are at this challenging this additional increment, and you pray before us that we may set aside this grant after 27 years, 26 years.
No, 26 years is, he was not granted. In fact, the granting order, it is there, my lord, I have read. My lord, that was a common order passed by the general office subject to 5 conditions. And he did not. We can make a statement, file an affidavit to that effect. My lord. We can file an affidavit. We can file an affidavit. We'll file an affidavit. Lordship.
Item 37.
Before my learned friend starts, my lord, the complete pleadings before the learned single judge is not in the memo of appeal, my lord. My affidavit in reply and an affidavit of the state respondents, my lord, that is not part of the memo of appeal.
You file it.
I'll file it. I'll bring it on record.
Good night.